topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Experts show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Experts. We bring you the top experts in the field of legal, health, financial, and home improvement. This is the first Thursday of the month, and that means Kay Bender Rimbaum. We have an incredible show for you today. I do have to give you some new instructions about the show. This is, with 60 shows, this is our most popular show. We get more phone calls, we get more emails, we get more text than any show we do, which means I have a lot more work. In the past, we have been taking your questions on the chat line. I am not going to be able to do that anymore. So you're going to have to email your questions in to Stephen at AskTheExpertsRadioShow.com, or you can text me at 954-336-3767. It's just so much work between the phones and the chat line that we're just not going to be able to take your chats anymore. But we have a great show for you today. Let me welcome our great guest, board certified attorney Robert Kay. Good afternoon, Robert.
Good afternoon, Steve, and hello to everybody.
So good to see you. I love the first Thursday of the month. I know it's going to be, the show goes by so fast, Robert, and people love the way you address questions on community association law. Please tell everybody about the firm.
Okay, Bender Rembam, as we hope most of our listeners know, is a law firm that primarily works in the field of community association representation. We do that out of our offices in Pompano Beach, Palm Beach Gardens, Orlando, and Tampa. We have a meeting center in Miami by appointment, and we're available to our clients for all aspects of their day-to-day legal needs in operating community associations, involving opinions regarding restrictions within the documents and rights and obligations of the association and the unit owners, dealing with contract negotiation, finalization, dealing with construction defects, dealing with unpaid collection of assessments. Anything that the association will have a need for, we're available to provide legal assistance every day. We recognize that legal services of this nature are not something that needs to be a long wait to get an answer to. We try to provide responses to inquiries within a day or so of receipt. There's always a response indicating that we've received the inquiry if we can't do it immediately, if it's a more involved. But we do also strive to provide information in a format that's readily understandable to the layperson without the need for additional translation and assistance. So customer service is important to us, and we've been providing these services continuously since 1992.
You know, Robert, you talk about how important customer service is. You have offices not only here in South Florida, in Pompano, you've got Palm Beach, you've also got Tampa, Orlando, and you do shows for every one of those markets, not only
We do.
here on Ask the Experts, but you do classes every month, free classes, and you donate so much of your time to educating people.
We do that. And I also point out that of the 20 or so attorneys we have, roughly half of us are board certified by the State Bar of Florida, one of them in construction defect litigation, the rest in community association legal information. So being board certified is a rare situation, and there's maybe 200 in the state of Florida, and we have roughly 10 of them. So we're proud of that accomplishment. In fact, our friend Alan up in Orlando recently joined the club.
I was just going to say that by the time he comes on this month, board certified.
Yeah, he got the news.
So let's get started. What we do is you write in your questions to us, and I got to tell you, there's a lot of duplicates. A lot of people have the same questions, and we just try to, because the show is only 50 minutes, so we can only get so many in. But here's a great example. This is from Jill in Boca. She wants to know, how do we find out about the vendors our board is hiring? Shouldn't the owners be involved in that decision? We get a lot of questions about owners being involved. So have at it.
I mean, the owners generally are not involved in those decisions. They're certainly welcome to voice opinions to the board, but it's the board of directors that makes the decision as to vendors for the association. The structure of associations are such that unit owners choose their representation of the board of directors. The unit owners vote on amendments to the governing documents. Unit owners vote on issues such as waiving or reducing reserves where applicable, and material alterations to common areas and condominiums, but not much else. The operating decisions for the association fall to the board of directors. That being said, all of the information of vendors should be available to the membership in the official records of the association. And in many such communities, they're posted on the website that's been maintained by the association. So that should be a possible source. But if that's not available, a written request for inspection of the official records should be submitted to the board, an appointment made so that that information can be found within the records of the association. The association is not obligated to answer a question of, hey, who's the vendors? That's not a legal requirement. They are required to provide you access to the official records to go through them and identify them.
Let's go to Larry in Boca Raton. How do I find out the association records so I can look them over?
Well, that's very similar to the prior. You make a written request to the association. Ideally, you'll do it by certified mail with a return receipt, just in case that's a requirement of your association. Then you'll have a written record of it. You can send an email. It just has to be a written request. Some communities do have specific rules in place as to how the requests are to be delivered, and many do have certified mail requirements, which have been found to be a legally acceptable requirement. So it's safest to make the request that way. You'll have a record of when it was delivered. The association has 10 business days to provide that access during reasonable business hours, and that should get you the information that you need. If you don't get that access within that time frame, if you're in a condominium, you can go to the Division of Condominiums Enforcement section to indicate that the association has failed to provide you access, and they will assist. If you're in a homeowners association, there is no such opportunity. You'd have to bring legal action in court, which is a little bit more of a requirement for the owners, because obviously you'll be involved with the court system. You may have to spend some money on legal assistance. It's not necessarily recommended to file it without an attorney, but it can be done by an owner if they want to take on that challenge. So those are the options for that.
We just got our first text from a listener. They said, oh, this is an unusual question. They said, I heard that the legislature, of all the legislators, only one of them have ever lived in a community association. How do they decide on laws when they've never lived within an association?
Well, I don't think that's a true statement that only one of them has ever lived in a community association. We've heard stories of many of them. In fact, quite often the legislation evolves because a particular legislature has an issue in their own association, and suddenly that gets incorporated into legislation that's going to affect the whole state. There's many things that go into the creation of legislation. There's a large group of people among the staff of the legislators that participate in the reviewing of and the drafting of and the back and forth through committees before it gets presented. It's a very involved process. Usually bills are starting to be proposed in around this time of the year for the next legislative session, as they're going through the various machinations, as it were, of getting it into a format for the final presentation. The remainder of that answer is that it's politics, and whatever the side gets to the legislator's ear sufficiently to make them make their decision. It's often very difficult to predict how it's going to go.
Let's go to Jenny in Delray regarding mandatory reserves. Please explain, I could even answer this one. Please explain single-story condo reserves. Should we still fund the reserves?
Well, if you can answer, go for it. But
well, you can't. There isn't a single story.
If it's from me. Well, there are single-story condominiums, and the latest legislation that has the higher level of reserve requirements applies to 3 stories and above, but that doesn't take away the obligations that existed before. The requirements of reserves that have always existed for condominiums remain in place for those that aren't affected by the more recent legislation. So your painting, paving, roofs, and any deferred maintenance item of over $10,000 would be part of what's in the reserves that you're required to maintain. You still have the ability to reduce or waive to a certain point, but it's strongly recommended that any consideration in addressing reserves at this time, there be consultation with the association's attorney before making any final decisions on that, to make sure that you're in complete compliance with what the legal requirements are.
Okay, this is just came in. This is from Ben. Ben wants to know, with all the new laws, do you feel safer? I guess they mean,
do I feel safer, or does anybody feel safer? I think it's too soon to say. If he's referring to the structural integrity of the buildings, it's a little too soon to say whether what's been done is going to make a difference. I don't think there is widespread deterioration going on to the extent of what was experienced by the collapse, the tragic collapse that occurred some years back down in Surfside, that prompted all this legislation. There's been what many consider an overreaction to that, which is not an uncommon occurrence when dealing with legislation. And over time, there may be opinions that change that might roll it back some. It's going to create some significant expenses to a lot of places that are going to make condominium ownership a little difficult for some time, and how long that lasts is difficult to predict. But it's coming into play over the next couple of years, so we'll see how that shakes out. I didn't feel unsafe before, but think anything can happen.
Here's another text that just came in. This is a board member. I love your show, and I respect your opinion and your knowledge. What do we tell owners who are so worried about the future with condo owners, with rates going up, insurance rates going up so high, and everything going up so high? What do I tell these people?
Well, if I had a good answer for that, I probably would be in demand. But unfortunately, every community is going to be facing its own set of challenges, depending on the age, the construction, whether they did the maintenance that was required appropriately through the years, whether that was let to go. So it's hard to generalize. The legislature has made efforts to do things that in the long term, the hope is insurance rates will come more under control. I think we're seeing maybe a slowing of the increases, but we're not seeing any significant decreases at this point. It's becoming incredibly expensive to operate with the insurance requirements that exist. Everybody's got to make their own decision as to what's financially reasonable for them, and each board of directors has to be diligent in keeping up with the requirements, as well as observing its own financial circumstances and conditions to make sure that things don't result in significant and catastrophic financial impact to its owners. And how that's done is going to be on a case-by-case basis. And it's going to take a team of people to assist with that. Certainly good management is important. Having a good legal assistance will be necessary. There may be certainly some time for getting all the engineering requirements, so you find out the complete status of the buildings that are involved in the condominium. So it's going to be a number of years, unfortunately, before this all works through.
Robert, give everybody the phone number. You have an 800 number that's good for all your offices. And let's give everybody your website.
You can reach us at 800-974-0680. You can write to us at info@kbrlegal.com, or you can go to the website, kbrlegal.com. There's a contact box on the opening page. While you're at the website, you can click on the resources tab, and you can look at articles in Rembaum's Association Roundup or Legal Morsel that go back many years and have all sorts of topics in them. You can also go into the calendar and identify some of the events that are upcoming and register for participation.
We're going to go to break right now. When we come back, you've got a pretty busy schedule for June. We're going to go over the schedule for your classes coming up. We're going to go to break. We'll be right back.
Okay, Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the first Thursday of the month, which means K. Bender Rembaum, Community Association Law. We are here with board-certified attorney Robert K. Robert, you've got a lot of classes coming up. Let's go over those.
All right, starting on June 10th, next week, 11:30 a.m., there's going to be a 2024 legislative session update. There'll be a panel discussion. Lisa McGill from the Pompano office will be participating. It's hosted by CAI's Florida Legislative Alliance. So that's Monday, June 10th, 11 a.m. June 12th at 12 noon. And by the way, these are all by Zoom. None of these are in person. Hurricane Preparation for Associations, hosted by Castle Group. Michael Bender and Jeff Rembaum will be participating in a discussion about the legal aspects of hurricane preparation since we're at the beginning of that season. June 18th at 12 noon, Importance of Updating Your Governing Documents, hosted by Campbell Property Management. Emily Gannon from the Pompano Beach office will be providing information on updating your governing documents. And on June 20th at 9 a.m., Weathering the Storm, Effective Condo Leadership. Another panel discussion hosted by Silcotech, and Lisa McGill from Pompano will be among the panelists. And at June 21st at 10:30 a.m., the MIR and SIRS, legal requirements. Kirsten Hentz from our Tampa office will be presenting, and that's hosted by GRS Management. And on June 25th at noon, new legislation is coming. Is your community association ready? Michael Bender from the Pompano office will be presenting, and that is hosted by Campbell Property Management. That's what's upcoming for June.
Busy month. You know, you had mentioned about the hurricane prep. We have received so many letters, and we give them your office number. People wanting to know about hurricane prep. So that should be a really good one.
Yes, that does get a lot of participation. So next Wednesday, 12 noon.
And I want to give out, we have a lot of people who are asking for our number again, that they can text us, 954-336-3767. A lot of people have questions for you. Just send those over and we'll get you on the air. Let's go to Richard in Palm Beach Gardens. I would like to know how to handle board members that don't answer questions.
Well, it would be helpful to know what kind of questions he's talking about. And I don't think he identified HOAs or condos. So there's different procedures that are involved for the two different types of ownership. In a condominium, the statute provides that any owner can submit by certified mail a written inquiry to the association, which the association is required to provide a substantive response within 30 days. Or if they submit it, refer it to the association attorney, then there's an added 30-day time frame, so 60 days total. And so, it's got to be a relevant question to the association operation, as opposed to things that are not within the scope of the association board. So asking a legal question to the board is not within the scope, because the board doesn't, they're not lawyers and they don't give legal opinions. So that wouldn't be the type of inquiry that should be presented. Unfortunately, there's no similar provision for owners in the homeowner association statute. So it might require involving independent attorney to push the issue with the association if there are information requests that are being ignored. Generally speaking, the law doesn't impose significant requirements on board members to respond to verbal inquiries. It's good politics at meetings if owners have questions for board members to respond, but that's politics. It's not necessarily legal. There may be reasons that board members shouldn't be responding. There may be active litigation involved or pending litigation involved that is premature to be discussing in a public forum, or the association attorney has advised them not to talk about it. So that could be a situation as well. Questions about the general association operation should be something board members should be able to respond to. If the board is stonewalling owners for information, another option for owners to consider is removing them, recalling the board members, and replacing them with other individuals who might be more responsive to the owners. That's assuming that the upcoming elections for the board are longer than 60 days away, or have occurred more than 60 days in the past, because that time frame is not open to recall. So 60 days before, 60 days after an election is open season, but not during that time frame. So those are the basic options I could think of.
Robert, a good friend of mine in Texas, is a president of their association, and he said he must get, between the time he leaves his door, goes through the halls, goes to his car, 10 people stop him with questions. And he probably gets about 20 questions a week. I think people don't realize these board members, they just think about their question only, but there's 30, 40, 50 other people who have questions also. It's a tough position.
Well, we've had clients that will have a policy. If you have a question, then just submit it in writing and the board will respond to it. These board members, they're also homeowners, unit owners, and they don't live and breathe the association necessarily, although many of the owners want them to. And they're not at their beck and call. They have personal lives as well. So you have to respect that.
Absolutely. We're going to go to Ken in Boca Raton. He is a new board member, 5 months. They have 5 board members. They have a new president who's gone through a lot of money. No board approval for all the money he is spending. What is the best way to make homeowners aware of all this money the new president's spending? Can we take the presidency away from him?
We have multiple questions there. There's nothing that precludes board members from communicating with the unit owners about issues that involve the association. So they can send emails, they can send letters, they can speak, so long as what they're saying is true. If the president serves at the pleasure of the board, it's not a dictatorship, is not somebody that can just run amok. The president can't spend money that isn't authorized by the board, should not be doing so. And board minutes should reflect the authority that the board might provide to a president, what limits there are in spending without having to come back to the board. And so at any board meeting, an agenda item can be reorganization, and then the board can vote to remove the president and replace it. Now, I would caution that with one caveat. In some very rare communities, there are some out there, they have provisions for the owners vote for the officers, and that's in documents that are significantly older, and it's not common, but we do see it from time to time. So confirm that your documents allow for the board to decide who's going to be the officers, and they can do that at any time.
Okay, let's go to Rex in Boynton. Developers are turning the board over to us. We are having new elections next month. Can the new board go directly into an organizational meeting? This would be to elect officers.
Well, that's one of the things an organizational meeting does. There are other things to take into account. You want to make sure you address signatories on bank accounts. You want to address, if you have association counsel, who among the board is authorized to speak for the board to the association counsel, so as you to keep your legal bills under control and the legal advice you receive under control. Because if you have 5 different people calling the attorney with the same question with a different slant, you might get different answers to it. So you want to funnel your legal questions directly. You will want to check your bylaws and or articles of incorporation to confirm that following an election, the time frame for an organizational meeting. It's unusual that it has a specific requirement. Many times we see it'll provide that the organizational meeting can be held within 10 days of the date of the annual meeting without further notice if that's announced at the annual meeting or the election meeting that you're having with the developer. If there's going to be an organizational meeting immediately following the election, there should be a notice of that meeting in advance that immediately following the annual meeting, the organizational meeting will be held. The developer should include that in the notice of the meeting, and you might request that of the developer to see if they'll do that. There is the issue of sometimes you don't know who you want to do what. So if you're not prepared and you don't know who's going to be elected, you're not prepared to do that, it might make sense to schedule that not immediately, but in the days that follow the election. So those are the various choices.
Okay, here comes another text just came in. Does 720.3045 give the homeowners the right to install a fence or a hedge in the backyard not visible from the front street to block the next door neighbor's view of items stored without an ARC approval?
That's going to be a document-specific thing initially, but there is legislation that was adopted last year and enhanced upon this year about such limitations. There is a question as to whether that legislation is constitutional, because we're talking about substantive vested contractual rights of a declaration of covenants. And if there isn't specific language that automatically incorporates changes in the legislation, adding such restrictions to the documents or limiting the ability of an association to enforce restrictions of documents by the legislation would have a constitutional problem of impairing an existing contract, which both Florida and U.S. constitutions do not allow. There hasn't been any legal challenges that have gotten to the appellate level that I've seen on that issue yet. it's possible most associations are just going to go along with what's in the legislation and accept it. But that is one item that was put in last year that limits the ability to enforce things that aren't visible from the street or from an adjoining lot. So that could likely apply to this set of circumstances. I do suggest consultation with association counsel more specifically on that, rather than relying on what I'm saying.
This next question, we are starting to get more and more questions like this. This is from Jack in Aventura. Can the board repurpose the reserve money for a pickleball court from a conversion of tennis courts? We are getting a lot of letters about that, Robert. People wanting to convert tennis courts into pickleball.
Well, does it say condo or HOA? The question
Condo.
Doesn't identify. It says condo. Okay. Well, one of the issues of concern in converting tennis courts to pickleball is that would qualify as a material alteration to the common elements that may require a vote of the owners. So you need to check your documents to see whether a material alteration of that nature is going to require an owner vote in it. What amount of owners have to vote to approve that? If the documents are silent on that issue, the statute provides for a 75% owner vote. As to the reserve money, if it's reserved for a tennis court and the tennis court's going away, it would seem that may not be as much of a repurposing of those funds, arguably. But for perfect safety, there would be a vote of the owners to reallocate the reserve money from tennis court maintenance to construction of pickleball and maintenance of that.
Okay. Let's go to John and Davy. No, that's a question we've already answered. Let me go to Mary in Coral Springs. She has a condo. If your docs are changed and you never voted for it, do I have to go by the new rules?
You said condo, yes?
Yes.
For the most part, the answer is yes. There is some exception to that. That goes back almost 20 years in the legislation now. If the change involves leasing rights and creates restrictions on leasing, the law provides that it's only applicable to the units that vote for it or those who acquire title after it was adopted. So say you own in a condominium and they adopt amendments that say that you can't lease your unit more than once every 5 years, and you don't vote in favor of that. Under the statute, you're not bound by that. You're able to lease it as you were before. But every other amendment is going to be, most every other amendment is going to be fully enforceable. The Florida Supreme Court had a ruling on that around 2005. That when you buy into a community, it has a set of governing documents that are in the public record, and those documents are subject to amendment when you take your property subject to the possibility of amendment. And so long as the amendment isn't violative of any laws, like creating discrimination, let's say you say no children under 16 can live in the community, and you don't qualify as housing for older persons under the federal law as well as the state law, then that would be the type of amendment that would not be enforceable and could subject the association to problems. But generally speaking, all amendments are going to be enforceable against all owners, whether they vote in favor of them or not.
Okay. Let's go to Stephen in Pompano Beach. With all the new rules and regulations for condos, is it going to be harder being a board member?
Well, there's still a bill pending for condominiums that hasn't reached the governor's desk yet. And that bill contains requirements that could make it harder to get board members, because there's a larger requirement of continuing education to remain certified than used to be there in the past. And it's a voluntary position, and there are people that are willing to serve and get certified that would last them for 5 years. But if they have to take continuing education of so many hours every year, they may balk at doing that, which could cause a problem in getting board members. I don't think the additional requirements that were put into this pending bill that create certain criminal liabilities to board members is likely to create a large problem, because those criminal activities are things that the vast majority of board members aren't going to be doing. So they don't necessarily need to worry that much. But if the possibility of a criminal charge is of a concern to an individual, however remote it might be, that in and itself could create a lack of desire to put yourself in the forefront and take all the potential abuse that board members suffer in their communities.
Just got another text in. Is it illegal for the person teaching a class for certification not to be an attorney?
I don't think there's a requirement that the teacher be an attorney. The certification course has to be approved by the Department of Business and Professional Regulation, and they approve who's teaching. So as long as the course is certified through the requirements of the state administrative agencies, then there wouldn't be an issue as to the qualifications of the teacher.
Okay. Ronald in Delray Beach, can my association really evict me for unpaid assessments?
Well, it's not an eviction under those circumstances. It's a foreclosure that takes away your ownership interest in the unit, and then there'd be basically a writ of possession that forces you out. It's a faster process, and it's certainly much more traumatic than an eviction process, which takes a bit of time. The bottom line is the same, that you're out. You can lose your property. There are very, very few situations in Florida that your homesteaded property can be taken away from you. Mortgagees can foreclose on property, construction lienors can foreclose on property, and homeowners associations can foreclose, and condominiums and can foreclose on the property and take them away for unpaid assessments. If someone's having financial difficulties, it's imperative that they communicate with the association, this situation, however embarrassing that may be, and work out an arrangement with the association early on, so not to face a problem of having to deal with the additional costs and expenses that occur when they get referred to the attorney for collection and possibly foreclosure. Those fees and costs can get into the thousands of dollars relatively quickly. And if you are communicative and work with the most boards, in our experience, do have the ability to work with owners that are having those financial difficulties. But there is that possibility of losing your property if you don't pay. So that's a very important thing to keep in mind.
Yes. Jack in Lake Worth wants to know, he bought into a community and now I'm being told there are restrictions that I don't like. What am I supposed to do, as I was not told about these?
Well, unfortunately, when you buy real property, I'm going to say anywhere, but certainly in Florida, it's incumbent and required of the purchaser to do the due diligence to be aware of what's in the public record that is enforceable against your property. Declarations of restrictions, declaration of condominium are all recorded in the public records of the county in which the property is located. And if you are using the services of a bona fide title company, they identify all of these things in their reports that they prepare prior to the closing of the sale of the property. The associations have documents that they're supposed to make available to anyone who inquires. That's part of the statutory requirements on associations. So it's really up to each purchaser to make themselves aware, do what's necessary to discover what encumbers the property. And if they need the help of qualified legal assistance, then they should do so. To claim lack of ignorance, or lack of knowledge of what's encumbering the property is not a bona fide defense, and it can end up costing the owner much more money. It's not like it's my house, I can do with it as I want in most places. You're subject to these restrictions in addition to whatever local ordinances exist, as well as county and state laws.
I'm going to get this last question in for the night. Gary from Delray Beach. Do we have to do reserves for elevators?
Well, if deferred maintenance of the elevators is more than $10,000, the answer is yes. And I would think that in all likelihood, that will be the case, that any deferred maintenance on an elevator is likely going to exceed $10,000. So that would fall under the category of what's required by the statute. There is a good idea for all condominiums to have periodic reserve studies by independent experts to go through all of the property and identify things and create reserve schedules. It's important to do that not just once, but periodically, every few years, because things change and costs change, and it's important that associations stay on top of that.
Well, that's going to bring us to the end of the show. Robert, give everybody the phone number again and your website. It's probably one of the greatest community association websites.
Thank you.
Let's give them all the.
You can reach us at 800-974-0680. You can email at info@kbrlegal.com, or you can go to the website, kbrlegal.com, and put information into a contact box on the first page to indicate what your interests or needs are, and they'll get back to you. Any of those ways.
Well, another great show, Robert. Thank you again so much. We will see you again next month with more Ask the Experts.
All right. Thank you, Steve. Thank you, listeners. Have a good June.
Thank you so much, Robert. That's Robert K. Bender Rimbaum. Just a great community association law firm here in South Florida. Actually, they cover all of Florida. That's it for us tonight. We'll be back with you again next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.